NIOS welcomes you in this educational video for subject Political Science, Code 317, Senior Secondary Level, Lesson 12. Name of the lesson is Supreme Court of India. Let us first understand difficult words from this lesson. After that, we will begin the lesson. Court. Collegium. Original jurisdictions. Appellate jurisdictions. Court of record. Protection. Guardian of the Constitution. Civil cases and criminal cases. Judicial review. Public interest litigation. Judicial activism. We have discussed the difficult words. Now let us begin the lesson by looking at a view at the objective. The first objective is to recognize that India has a single, integrated and unified judicial system. We also will be able to describe the composition and organization of the Supreme Court of India. Also, we will be able to explain the powers and jurisdictions of the Supreme Court of India. Along with that, we will be able to appreciate the role of the Supreme Court of India as guardian of the Constitution and as a protector of fundamental rights. Also, we will be able to recall that public interest litigation means PIL. PIL plays an important role in the protection of our rights. So we have discussed the objective. Now let's get started. Here we will discuss the single, unified and integrated judicial system of India. You can see the three levels in a hierarchy: lower courts, then higher court and then Supreme Court. The Supreme Court stands at the top of this single integrated judicial system with high courts at the state level. There is only one Supreme Court, and in all states we have high courts. And below the high courts, there are several subordinate courts, such as the district courts, which deals with civil cases, and the session courts, which decide criminal cases. Now you can look at this image to understand the Indian judicial system. At the lower level, we have subordinate courts. It is also known as lower court. Further next to it are the High Court and then Supreme Court. We know that Supreme Court is the highest judicial authority of India. And Supreme Court consists of the Chief Justice and 25 other judges. The Parliament may increase the number of judges if it deems necessary. Besides the Chief Justice, there were only 7 other judges. The Parliament has increased the number of judges from time to time. As in 2005, there are 25 judges besides the Chief Justice, who is also called the Chief Justice of India. The Chief Justice and other judges of the Supreme Court are appointed by the President of India. While appointing the Chief Justice, the President is constitutionally required to consult such other judges of the Supreme Court as he deems proper, but outgoing Chief Justice is always consulted. Normally, the senior-most judge of the Supreme Court is appointed as the Chief Justice of India, although there is no constitutional requirement to do so. While appointing other judges, the President is bound to consult the Chief Justice and other senior judges if he deems proper. Whenever there is vacancy or a likely vacancy in the Supreme Court, the Chief Justice and 4 other senior-most judges consider various names and recommend the names of the person to be appointed as judges of the Supreme Court. This system is based on a ruling of the Constitutional Bench of a Supreme Court, handed down in 1993 and reinforced in 1999. Thus, while the Constitution still provides that the President is the appointing authority of the Supreme Court judges, the ruling of the Supreme Court has since 1999 become virtually binding on the President. Let us now understand the collegium system. The power of selection of judges has passed on to a group of Supreme Court judges called the Collegium of the Court. The President now performs the formality of appointing the nominee of the Supreme Court after the Law Ministry formally recommends these names to him. Break. Break.
प्रकाशित करने, राहों को आलोकित करने।
जीवन ये प्रकाशित करने, राहों को आलोकित करने। हम अपना दीपक स्वयं बने, हम अपना रास्ता स्वयं चुने।
अपना दीपक स्वयं बने, हम अपना रास्ता स्वयं चुने।
जीवन ये प्रकाशित करने, राहों को आलोकित करने।
धन साधन समय की सीमा से विद्यालय जो मुक्त हो।
धन साधन समय की सीमा से विद्यालय जो मुक्त हो।
कभी पढ़े हम कहीं पढ़े, वे विषय की लोट से युक्त हो।
कभी पढ़े हम कहीं पढ़े, वे विषय की लोच से युक्त हो।
मित्रों हम उठे और जागे,
मंजिल आने की ध्वनि सुने। हम अपना दीपक स्वयं बने, हम अपना रास्ता स्वयं चुने।
जीवन ये प्रकाशित करने, राहों को आलोकित करने।
राष्ट्रीय मुक्त विद्यालय का है द्वार खुला सबकी खातिर।
शिक्षा परीक्षा का अवसर एक बार ही क्यों मिलता फिर।
शिक्षा परीक्षा का अवसर एक बार ही क्यों मिलता फिर। दुनिया में इसके केंद्र बहुत,
कोई मन चाहा केंद्र चुने। हम अपना दीपक स्वयं बने, हम अपना रास्ता स्वयं चुने। कोई मन चाहा केंद्र चुने।
Let us get started again. Let us now here understand the qualification which is required to be appointed as a judge. A person is qualified for appointment as judge only if she or he is a citizen of India, and along with that, that person has been for at least 5 years a judge of a high court or of 2 or more than 2 such courts. If he or she has been for at least 10 years an advocate of a high court or of 2 or more than 2 such courts. And beside that, if he or she is, in the opinion of the President, a distinguished jurist. Tenure. The Chief Justice of India and other judges of the Supreme Court hold office till they attain the age of 65 years. A judge may voluntarily resign before expiry of his term. In exceptional cases, a Supreme Court judge may be removed before the age of retirement, according to the procedure laid down in the Constitution. Let us now understand the removal process. A judge of the Supreme Court can be removed from office by an order of the President passed after the address by each House of the Parliament, supported by a majority of total membership of the House and not less than 2/3 majority of the members of the House. The House members who are present and voting and passed in the same session has been presented to the President for such removal on the grounds of proved misbehavior or capacity. So far, proceedings for removal were initiated only in one case against a judge of the Supreme Court. But he or she could not be removed because the resolution could not be passed by the Parliament. It is clear that Supreme Court judges enjoy security of tenure and the executive cannot arbitrarily remove them. No person who has held office of a judge of the Supreme Court is allowed to plead as an advocate in any court or before any authority within the territory of India. And the Supreme Court judge who has retired cannot be a lawyer for anyone. The judges of the Supreme Court are paid such salaries as are determined by the Parliament from time to time. Court of record. The Supreme Court is a court of record. It has two implications. All its decisions and judgments are cited as precedents in all courts of the country, and they have the force of law and are binding on all lower courts and indeed the high courts. As a court of record, the Supreme Court can even send a person to jail who may have committed contempt of the court. Jurisdiction of the Supreme Court. The scope of power of Supreme Court to hear and decide cases is called its jurisdiction. The Supreme Court has three types of jurisdictions, namely original, appellate, and advisory. Original jurisdiction. There are certain cases which fall within the exclusive jurisdiction of the Supreme Court. It means that all such cases begin or originate in the Supreme Court only. It also means that such cases cannot be initiated in any other court. The cases or disputes that come under the original jurisdictions are mentioned on the upcoming slides. Dispute between Government of India on the one side and one or more states on the other side. B. Disputes between the Government of India and one or more states on one side and one or more states on the other side. C. Disputes between two or more states. The Supreme Court has been invested with special powers in the enforcement of fundamental rights. In this connection, it has the power to issue directions or writs. Cases under public interest litigation can also be heard directly. This is an extra constitutional practice. There is no mention of PIL in the Constitution. Break.
करने राहों को आलोकित करने
जीवन ये प्रकाशित करने राहों को आलोकित करने हम अपना दीपक स्वयं बने हम अपना रास्ता स्वयं चुने
अपना दीपक स्वयं बने हम अपना रास्ता स्वयं
जीवन ये प्रकाशित करने, राहों को आलोकित करने।
धन साधन समय की सीमा से विद्यालय जो मुक्त हो,
संसाधन समय की सीमा से विद्यालय जो मुक्त हो।
कभी पढ़े हम कहीं पढ़े, वे विषय की लोच से युक्त हो।
कभी पढ़े हम कहीं पढ़े, वे विषय की लोच से युक्त हो।
मित्रों हम उठे और जागे,
मंजिल आने की ध्वनि सुने हम, अपना दीपक स्वयं बने हम, अपना रास्ता स्वयं चुने।
जीवन ये प्रकाशित करने, राहों को आलोकित करने।
राष्ट्रीय मुक्त विद्यालय का है द्वार खुला सबकी खातिर।
शिक्षा परीक्षा का अवसर एक बार ही क्यों मिलता फिर।
शिक्षा परीक्षा का अवसर एक बार ही क्यों मिलता फिर। दुनिया में इसके केंद्र बहुत,
कोई मन चाहा केंद्र चुने हम, अपना दीपक स्वयं बने हम, अपना रास्ता स्वयं चुने। कोई मन चाहा केंद्र चुने
Let's get started. After the break, we were discussing about the appellate jurisdiction. The power of a superior or higher court to hear and decide appeals against the judgment of a lower court is called appellate jurisdiction. The Supreme Court has vast appellate jurisdiction. It hears appeals against the judgment of the high courts. It is the highest and the final court of appeal. If one of the parties to a dispute is not satisfied with the decision of the High Court, one can go to the Supreme Court and file an appeal. The appeals can be filed in civil, criminal, and constitutional cases. Let us now understand the appeals in civil cases. Disputes relating to property, marriage, money, contract and service, etc. are all called as civil cases. If a civil case involves a substantial point of law of public importance needing interpretation of the Constitution or law, an appeal against the High Court decision can be made to Supreme Court. Earlier, the financial limit of such civil cases was rupees 20,000, but now according to the 30th Amendment of 1972, there is no minimum amount for taking a civil appeal to the Supreme Court. If substantial questions of interpretation of law or constitution is involved, appeal may be made against the decision of the High Court. Let us now understand the appeals in criminal cases. An appeal may be brought to the Supreme Court against a High Court decision in a criminal case in a number of situations. Firstly, if a High Court sets aside an appeal or an order of acquittal passed by a lower court and awards death sentence to the accused, he may bring an appeal to the Supreme Court by right. Secondly, appeal can also be made to the Supreme Court if the High Court withdraws a case from a lower court to itself, declares the accused guilty and awards death sentence. In this situation, also appeals can be made as a matter of right and without certificate from the High Court. The appeal in cases other than these two categories may also be brought to the Supreme Court. Cases related to violation of fundamental rights and PIL can be directly appealed in Supreme Court or High Court. Court provided the High Court grants a certificate that the case is fit for appeal to the Supreme Court. Let us now understand the appeal in constitutional cases. A constitutional case is neither a civil dispute nor concern a crime, nor concerning a crime. Cases related to writs which involves violation of fundamental rights. Example, Kesavananda Bharati case where basic structure of constitution cannot be changed was defined. It is a case arising out of different interpretations of constitution, mainly regarding the fundamental rights. In such constitutional cases, an appeal can be taken to the Supreme Court only if a High Court certifies that the matter in dispute involves a substantial question of law. If the High Court denies a certificate of fitness to appeal to the Supreme Court, the Supreme Court can use its discretion and grant special leave to appeal to itself in any case it deems fit. Advisory jurisdiction. This power implies courts' right to give advice if sought. Under advisory jurisdiction, the President of India may refer any question of law or public information to Supreme Court for its advice. But the Supreme Court is not bound to give advice. In case the advice or the opinion of the court is sent to the President, he may or may not accept it. The advice of the court is not binding on the President. So far, whenever the court has given its advice, the President has always accepted it. The court refused to give its advice on the question whether a temple existed at the spot where Babri Masjid was built at Ayodhya. So we have discussed the lesson. Thank you.